Good morning, everyone. I'm Chris Tortorelli. I'm an assistant professor in the social work program at Mount Royal University. And with me is Jonathan Nicholson. Jonathan, do you want to introduce yourself?
Yes, thank you, Chris. I am a lawyer. I've been a lawyer for approximately 40 years. Most recently, for the last number of years, I've been the director of the Alberta Justice Family Law Office, which deals with a number of ministry clients such as Child and Family Services, Maintenance Enforcement, Alberta Trustee and Guardian, and we deal also with international child abduction matters.
Great, thanks, Jonathan. So today we're going to demonstrate for you some of the court processes that you might hear about or be a participant in, depending on where you land in your career as a social worker. So you're going to see a caseworker in court, and you're going to see an expert witness in court, and Jonathan is going to take the role of a judge and also a defense lawyer. So we're going to change roles a little bit as we move through this session. So don't get confused if you see us doing different things, because that's just how it's going to go. And we'll walk you through that. So we're going to use a case which is made up from a number of sort of real situations, but all put together in one created case, just to give you a sense of what the court process might look like. Jonathan, do you want to talk a little bit about the court itself and maybe some of the differences between Court of Queen's Bench and family court?
Certainly. The court process is a very formal environment. There are strict guidelines with respect to the evidence witnesses can give, the role of counsel, lawyers, and also to some extent the judge or justice themselves. It is based on what's termed the adversarial process. The premise being that by virtue of having an adversarial process, the truth will come out. And there will be witnesses there, both for the applicant and witnesses also for the defendant. The witnesses can be what are called ordinary or lay witnesses, and you can also have witnesses that are qualified as being expert witnesses based on the premise that they have a particular expertise that can assist the judge in coming to a resolution of the matter before the court. There are some differences between the levels of court here in Alberta. You have the provincial court, which is the lower level, and in that situation, the lawyers will not wear robes. You'll see them generally in suits when there is a trial. In the Court of Queen's Bench, the lawyers will wear a formal attire called robes, which I'm wearing here today. In the provincial court and the Court of Queen's Bench, during trials or hearings, there's evidence given by the witnesses as indicated. With the Court of Appeal, there are no witnesses before the Court of Appeal. The matters brought before the Court of Appeal are based on the evidence and information given at the trial of one of the lower courts. There are some distinctions between child protection matters in the provincial court, which has jurisdiction when matters are initially brought, and the Court of Queen's Bench being a superior court. In Court of Queen's Bench matters, where matters start there are a specific number of parties. This can be in civil matters and criminal matters. In civil matters, there is the plaintiff who brings the action, and then the defendant who is defending the action brought by the plaintiff. In criminal matters, whether they start in the provincial court, criminal jurisdiction, or in the Court of Queen's Bench, there are basically two parties to the proceeding. That is the state, sometimes referred to as Her Majesty the Queen, and then there's the defendant, who is known as the accused. It can be somewhat different in child protection proceedings in the Provincial Court of Alberta. In those proceedings, the parties are the Director of Children's Services, the guardians of the child or children, and also the child or children are parties. So they have that status in a provincial court child protection hearing. Conversely, if it's in the provincial court or the Court of Queen's Bench, the children are not parties to the proceedings. Okay? The only parties are, for example, the state, as I mentioned, and the accused. So there are subtle differences there, given that a child who may make a disclosure to a child protection worker, that disclosure can be admitted by someone who's heard that disclosure, such as the child protection worker, because the children are parties. Conversely, in the criminal division, you could not have the evidence of what the child said given by a child protection worker or any other party. You would have to have the child called to give evidence directly in that proceeding. Conversely, in the child protection proceeding in provincial court, the child can be represented by a lawyer. So those are significant distinctions to bear in mind, depending where the proceeding is and what type of proceeding it is.
Perfect. Thanks, Jonathan. And today we're focused in on child protection in a family court setting. So it's important to just understand those pieces. And Jonathan's talked a little bit about how that works and the differences in the court levels. I want to just talk a little bit about rules for social workers. So there are some rules, and when I started as a caseworker in child protection, I was given some rules right off the bat. I was told to make sure that I had appropriate dress. So you'll see that I'm wearing a skirt, something professional, not too flashy, very, very sort of court appropriate attire is I guess what that's called. When you're in the courtroom, you're not to be chewing gum. They like your hair pulled back so they can see your face. They have microphones all over the courtroom. And so it's important that there aren't any side conversations. There's no phones that are on, vibrating or ringing. So really there's a lot of attention paid to the I guess the sanctity of the court and making sure that everyone is respecting that. Also, when you enter or leave the court as a child protection worker, you bow. So you just bow briefly when you enter the court to the judge, and you bow when you leave. And so those are some pieces that you might not know about court. Most courts are open, and so if you get a chance to go down and sit in and watch, you're able to do that, and it's a great learning experience for students and social workers alike.
Just one thing I'd add about the microphones. Remember that even if the court is adjourned, which means the judge leaves the courtroom, those microphones are live and they will record anything you say. And there have been certain situations where that has proved to be somewhat concerning for individuals. There have been adjournments where one of the parties, usually one of the parents, for example, is very upset with something like the lawyer for the director or the caseworker, and has made verbal threats, which have in turn been played back when the court reconvenes and could lead to criminal charges. There are also times when certain people, maybe spectators, extended family members, have made disparaging remarks about the judge when it's adjourned, and then that is played back and the judge is aware of that. So be very cautious. Do not think that the microphones are turned off.
Right. I mean, I think the word for me is respectful. Everything that you do in that court process needs to be respectful, including coming prepared to give the evidence that you're there to give. There are some roles that we just want to quickly run through before we get started on this case. So you're going to hear the words delegated caseworker. And so that is a person who is employed by the Ministry of Children's Services and has completed all of their training and is delegated to carry out all of the duties of a caseworker and all of the areas under the Child, Youth and Family Enhancement Act that are delegated to their level. And so you'll hear that term a fair bit when you're watching or hearing court, and you'll hear that a bit today. Jonathan, there's counsel for the director, which you've talked about a little bit. The director is really the Minister of Children's Services, and the minister delegates duties to other people within Children's Services. So you'll hear that word director referring to Children's Services.
Right, so the director does not appear in court. Who appears on behalf of the director, as Chris has indicated, is the delegated worker to represent the director.
Counsel for the parents.
Counsel for the parents are lawyers in private practice out in the community. They can either be directly retained by the parent themselves, or very often in these cases, the parents are able to obtain counsel through the Legal Aid Society of Alberta.
Right, and then you had mentioned counsel for the child.
Yes, there is a specific section in the Child, Youth and Family Enhancement Act that allows the court to appoint a lawyer to represent the child. These lawyers are provided by what's referred to as the agency Legal Representation for Children and Youth. They have a number of lawyers on their roster that are familiar and experienced representing children, and one of these will be appointed to represent the child or children as the case may be.
Yeah, and then witnesses. So both sides, the parents and the director, depending on what is happening in court, can call witnesses. And so those witnesses can range from other family members, a caregiver, to professionals in the community, police.
Right. Foster parents, visit supervisor, assessors. And with witnesses, as indicated, there are two types of witnesses, lay or ordinary witnesses, and expert witnesses recognized by the court who are thereby entitled to give opinion evidence.
And then structurally in the court, there's the judge, of course, and there's a court clerk. And so the court clerk is really the person who manages all of the administrative pieces going on in the court. So manages evidence that's submitted to the court, swears in witnesses, organizes the cases in the order that they're going to be heard, calls the cases as they are brought forward. So we aren't going to show you that piece today, but that is an important component of the courtroom. So I think that's all. And then we will stop here and launch into a case. And hopefully you'll enjoy what you see and have questions that can be discussed in class, and we'll go from there.
Hello, I'm Dr. Peter Choate. I'm a professor of social work here at Mount Royal University. And we're going to spend the next little while outlining the case for you. So the starting point is that child welfare receives a call, often to the 24-hour line. And in this particular case, on Monday afternoon, Child Intervention receives a call from a hospital social worker. And that social worker advises that the mom, whose name is Laura, was brought in last night, and 2 children were brought in with her as there was no alternative caregiver available at the time. The children can't remain in the emergency department. Mom is not able to provide care, she is incoherent, and a drug screen indicates a high level of cocaine in her system. Her heart is a concern, as is her breathing, and the prognosis is not known as yet. The children, both girls, are aged 3 and 6. So as I receive the call, the next step is to review the history. And in looking at the history in the child welfare system, what I'm able to learn is that there was a first call about 4 years ago when the oldest child was 2. Mom had not returned to the home as expected, and the babysitter was quite concerned. Grandmother is the emergency contact. Babysitter had the phone number and was advised to call the grandmother. The babysitter called back to say that she had done that, but the mother had just arrived home, and so thus she actually didn't contact grandmother, and the babysitter was ready to leave. The second call resulted in an investigation and an assessment, and a file was opened. In other words, child welfare became formally involved, and a family enhancement agreement was signed. This is a voluntary agreement and is designed to help families sort out issues that might otherwise cause them to become more involved in the child protection system. In this particular case, the call was received from the school indicating concerns about the care of the children. The 6-year-old indicated that she was taking care of her younger sister, getting breakfast for both of them when Mom was sleeping. The child was coming to school tired and is often arriving late. Mom's hard to reach. She doesn't want to talk when the school does reach them, and she didn't come to the last parent-child interview. The child states the mom acts weird after she's been in her bedroom for a while. After school, the 6-year-old says she gets home from school and looks after her sister, getting her bottle and getting her food. Sometimes she puts her to bed, and Mom is in her room, she thinks. The file is open for assessment. An assessment means we're now going to figure out what's going on and what are the degree of child protection concerns and what's the level of involvement required. So the assessor met with the 6-year-old at school and who provided similar information as the school had provided. Then there's a meeting with the mom. The 6-year-old wants to help all the time, so Mom lets her look after her sister sometimes, but Mom is always at home and supervising, she advises. Mom's struggling with depression and agrees to see her doctor. The family enhancement file is opened to assist Mom with parenting, supervision while Mom gets the help that she needs, and Mom says Grandma's a support, but they don't get along very well. Grandma tries to interfere with her parenting and takes over, and she's very critical of Mom. So the current situation is that we're going to transfer the file from me as an assessor investigator over to the care of Chris Tortorelli, who is the current caseworker. So Chris is going to tell us what happens next.
I am, as Peter mentioned, the existing or current caseworker for this family. And in Children's Services, what happens is that a call will come in, and if it's a new situation, it will be assigned to whoever is on the list for that day to take the case. If it's a case where there's already an open file, and there's someone who knows the family, it's assigned to them. So in this case, I know this family, and the file was assigned to me. It came in as what was deemed an emergency because of the nature of the mom's condition and the children being in the hospital emergency setting, which is not a great place for children, for sure of that age, who need supervision and support to be. So I talked to my supervisor and decided the next step was to head to the hospital, which I did. So I headed up to the hospital. I phoned first, so they knew that I was coming, and they could arrange for a space for me to meet with the children. So I got there, and the 2 children, Anne, who is 3, and Mary, who is 6, knew me, and they readily came with me to go and have a chat, find out what was going on. The 3-year-old, Anne, was really bouncing off the walls, and probably a little more so than I would typically think is okay for a 3-year-old. So a little bit distracted, a little bit upset. And the 6-year-old, Mary, was really somber. So she wanted to talk. She sat down beside me and she started to talk about what happened. So what she told me was that on the Monday, the mother was brought to the hospital probably overnight on the Sunday night, and the police and the ambulance had arrived at the house. They had taken Mom in an ambulance. She couldn't really describe that to me as an ambulance, but she talked about being taken from the home and taken with her mom to the hospital. She talked about over the weekend, since the Friday evening, they had had a babysitter, and that Mom had been in her room. At least that's where she thinks Mom was the whole time. They hadn't seen Mummy throughout that time, hadn't talked with her, and the babysitter was their primary caregiver. The babysitter was upset, left when the ambulance and police arrived, left crying. That was somewhat distressing for Mary to see. And then they arrived at the hospital. She told me that Mom's asleep, that she hasn't woken up, that Mary is scared, and that she wants to go to her grandma's. These children have a relationship with their grandma, despite the fact that Mom and Grandma don't get along very well. The kids often talk about Grandma. There is a step-grandpa in the picture as well. They don't talk about him so much, but definitely Grandma is a key support to them. So I leave the children with a volunteer from the hospital who's looking after them for the time being. Get an update from the medical team that Mom's condition is still really unsure about how she's going to, or when she's going to wake up and how her condition will be at that time. I call my supervisor to give the information and to have support and conversation about a decision. So no decisions get made just by me. I have to actually consult with some other people. So I do that. I try to reach Grandma. I leave a message. She's not home at that time. And the decision is that I will go to court and apply for an apprehension order because there is no available guardian to care for these children, to make decisions for them. And so they need to have somebody who can do that. And at this point, that is a court process. So I head off, and I guess I'll pick it up again next when I arrive at the courthouse.
This scenario will deal with an application by the child protection worker for an apprehension order, allowing the worker to proceed to apprehend the child and bring the child into care. The application can be made in a courtroom during regular court hours, or alternatively, if outside regular court hours, the application can be made by telephone. When the application is made, the caseworker will be required to be sworn in. There are a number of options depending on personal preference. Firstly, you can swear to tell the truth on a Bible or another religious book, such as the Quran. If you do not wish to swear on a religious book, you can alternatively choose to affirm to tell the truth. We'll now proceed with the application by the caseworker. The clerk will ask the caseworker, firstly, would you please state your full name for the record and spell your last name?
Christina Darlene Tortorelli, Tortorelli.
Ms. Tortorelli, do you prefer to swear an oath on the Bible or another religious book, or alternatively affirm to tell the truth?
The Bible, Your Honor.
Take the Bible in your right hand, please. Do you, Christine Tortorelli, swear to tell the truth, the whole truth, and nothing but the truth in these proceedings?
I do.
Thank you. Please proceed, Ms. Tortorelli, with your application. And I would point out that apprehension orders in the legislation may be made on an ex parte basis. This means notice does not have to be given to the other side, which in this case would be the parents or the guardians. This is somewhat unusual, but it is done for the reason that if the other side were to get notice, there could be the possibility of a flight risk or possibly violence perpetrated on other family members or the child. Please proceed with your application.
Thank you, Your Honor. I'm here today to request the granting of an apprehension order regarding two children, aged 3 and 6. The last name of the family is Adams. So Ann Adams is age 3, and Mary Adams is age 6. The two children are currently at the hospital. Their mother, Laura, was taken there by ambulance earlier today overnight on Sunday night. She's currently in the emergency department in serious condition. She is unable to speak. She is asleep, as the girls tell me, but unconscious according to the hospital professionals. They did a drug scan, and cocaine was found in her system. It is my understanding from the medical file and the information I received from the children that the mother was in the home from Friday night until Sunday in her bedroom using cocaine is the information that we believe of what happened. There was a babysitter caring for the children who then called Children's Services and the ambulance and the police. We subsequently received a call from the hospital because the mother is unable to care for the children. They are there with her, and I'm here to seek an apprehension order on their behalf.
And if this order were to be granted, where would the children be placed?
We are looking at the maternal grandmother. I've tried to reach her, and my colleagues at the office are continuing to try to reach her. Alternatively, they would be placed in foster care until we can reach the grandmother, who appears to be a strong support for the children.
I see. Very well. Your application is granted. The order will be in effect for 24 hours, and if police assistance is required, that will also be provided in the order.
No police assistance should be required. The children are at the hospital.
Very good. Thank you.
Thank you, Your Honor.
Order granted.
Good afternoon, Your Honor. Counsel for the Director. We're here this afternoon to begin a hearing for temporary guardianship. Dr. Choate is our next witness, and we are requesting that he be sworn as an expert witness for these proceedings. Dr. Choate, did you bring your CV with you?
Yes, I have.
Perfect. Do you need a copy for yourself?
No, I'm fine, thank you.
We'll ask the court to make this an exhibit for the proceedings. Could you please describe your educational qualifications, your experience, and your practice related to assessments?
Yes, so I have a PhD in social work from Kingston University in England, a PhD from from a university in New Mexico in addiction. I have a master's degree in social work and a Bachelor of Arts in psychology. I work as a professor in social work at Mount Royal University, where I have been part-time and then full-time employed since 1996. I am a registered social worker and approved clinical supervisor by the Alberta College of Social Worker, and I'm a registered clinical social worker. I work in the area of, clinically I work in the area of assessment of parenting capacity, and then I also do research in that area, and that includes cross-cultural research in terms of assessment. And in addition, I teach parenting capacity assessment as a continuing education program at the University of Calgary.
Perfect, thank you. Have you been sworn as an expert in court in the past?
Yes, I've been sworn approximately or a little over 150 occasions in the Court of Queen's Bench, the Provincial Court of Alberta in Calgary, Edmonton, Lethbridge, and Red Deer, and in the Court of Queen's Bench in Calgary, Medicine Hat, and also in the Court of Queen's Bench of Saskatchewan.
And in what capacity have you been sworn an expert?
So I've been sworn as an expert in social work with subspecialties in addiction and substance abuse, parenting capacity, child mental health and development, as well with related to that are issues around domestic violence and child development.
And in this case, you were asked to complete a parenting assessment with a specialization in addiction?
And parenting capacity.
Okay, and we are requesting that you be sworn as an expert in both a capacity of parenting assessments and addiction.
Yes, I would just clarify one small thing is as a result of changes in the Diagnostic and Statistical Manual of the American Psychiatric Association, we're not using clinically the term addiction anymore, we use substance use disorders.
Thank you for that.
So it's a technical change, but the APA has insisted on this change, so we should change our language.
Thank you. My friend may have some questions.
Thank you, Your Honor. I have no questions for this witness. You may wonder why I do not have any questions for this witness. The reason is this. You'll find most experienced defense counsel do not question a witness such as this on their qualifications, for to do so would only provide them with the opportunity to further expand on their expertise and make them look even better. And this is the reason I defer from asking this witness any questions in that area.
All right. Thank you for attending this afternoon, Dr. Choate. You completed a parenting capacity assessment and an assessment around substance use regarding Laura.
Correct.
Okay. If you could please advise the court what occurred during that assessment, what your results are, what your recommendations are.
Certainly. So we started with a consent process, and from there I did several interviews with Laura, and she, as I note in the report, she attended as scheduled and was cooperative throughout the process. The area that I spent a great deal of time reviewing that I think is relevant to the question is her history of substance abuse. Laura presents as having had episodic time where she has abused substances. At the present time, she feels that she is not abusing substances. And so she feels that the drug testing is incorrect, and she feels that while it is true that she has used cocaine around the time of the apprehension, that she was not doing so regularly, and it does not have a dependency on cocaine. As a result of that, we did have a look at some other factors, for example, what other substances that she might use, and she does report that she has used marijuana on quite a regular basis, but reports as well that she is cautious in her usage so as to not do it around the children. She does also report that as part of the episodic pattern is that there are times when she will binge drink, and she also tries to not expose the children to that. I did discuss with her that the pattern that she is reporting is inconsistent with the drug test result. It's a hair follicle drug test result. And it showed a pattern of usage over a longer period of time and at levels that would not be consistent with the presentation that she gave. I think one of the important questions when we get into exploring substance use, and so we spent some time then exploring Laura's history of trauma. And I think as she has explained to the child welfare worker, the relationship she has with her mother and her stepfather is not good. She did, and I say disclose, a particular issue which is not in the child welfare records. And I was careful to caution her that, again, as I often do with clients, to say, anything you tell me is on the record. But she wanted to talk about some early childhood trauma that she has worked with and has not disclosed previously, and which she describes as acting as a reason why she will episodically use substances. So you'll see in my report that she identifies a history of childhood trauma, and it involves her biological father, and she also reports a history of adolescent trauma, which involves a sexual assault by a boy who was roughly the same age as her when she was in her early teens. She indicates that she has not previously disclosed either trauma. And when I explored with her why she has done that, she says because she recognizes that may well have something to do with some of the issues that she's had in terms of parenting the children. And that she would like to be able to resolve those issues. She also acknowledged that when she is triggered, that she will use substances. I did a couple of observations, and I know that the child welfare record indicates that she has been not present at several, and She describes two things. One is that she actually was home on some of those occasions, but was having difficulty with the trauma, so didn't answer the door. And there were other occasions when she was not home. So what she began to describe then is a pattern of trauma, history not previously known, a usage of substances to calm that, and also trauma that causes her to avoid. So she says, for example, she won't go to the school because she doesn't want to have to deal with the school, as an example. When I went to the home and observed, she does have a tendency to let the older girl take over. So on the second observation, what I asked her to do was allow me to interrupt that to see what she would do if I sort of gave her a signal that she's allowing Mary to take over, and to see how she would respond to that. And I would say it's about a 50-50 sort of response. Sometimes she just continued to let Mary take over, and at other times she intervened. And so you'll note that in the recommendations that I've put forward to the court, or to the director, and would ask the court to consider, is that I have actually supported the temporary guardianship order, but I've done so for the purpose of therapeutic intervention. I think that what we want to do is refer Laura to a very specialized trauma therapist, also I would like to see her have a psychiatric assessment, not because I think that there's a dramatic psychiatric disorder, but I think that she is expressing difficulty with mood regulation related to the trauma, and it may be, and I emphasize maybe, I'm not a physician, but it may be that medication might help to calm her down so that she can engage the trauma therapy. I think as well the children should be in play therapy, because I think that particularly for Mary, I think one of the things that's important for Mary is to become a child again as opposed to a pseudo-parent, and let her explore her shift back into being a child and not having to be responsible for her younger sister. So I think play therapy, particularly for Mary, would be quite useful. I wonder about the younger child, because she does show in the visits she was quite hyperactive. And she's 3 or 4 years old. I mean, you're not going to diagnose anything at that point from a mental health perspective. But play therapy might be a way for us to begin to understand what's going on for her, because the inconsistency of the parenting environment as described by Laura and by Mary would be consistent with a child who would have difficulty with self-regulation. So there were moments in the visits, as I say, when Laura would take over, where she could show competent parenting, good enough parenting, and then there were moments where she wouldn't. She would stay out, and she would leave Mary in particular to look after the situation. As I'm sure you know, economically, Laura is struggling. She's had various low-paying jobs, minimum wage jobs. So I think we need to give some thought to other ways that we can support that family in terms of living accommodations, living structures, living situations. Ultimately, I think if therapy is successful, and I can't predict that therapy is going to be successful, but if therapy is successful, I think in 4 months' time we should revisit the assessment with a view to reconsidering what intervention is necessary. Long answer, sorry.
That's okay. So Dr. Trout, what would you say is the prognosis for change?
Prognosis for change is a risky territory to engage in, because you're attempting to determine what future behavior is. So I'm going to answer this differently in the sense of Laura has shown a willingness to explore her trauma. She's shown a willingness to engage in therapy. She has some insight into the impact of trauma. However, the opposing force is that she is still using substances for self-medication, and her insight in that area is low. Although I would caution to say that that's not uncommon because, as Dr. Gabor Mate, who's a significant addiction expert, will say, don't ask about the addiction. I use term addiction because he does. Don't ask about the addiction, ask about why the addiction. And I think in Laura's case, she's starting to do that. But what we have to find out is whether or not she can engage that therapy, be successful in that therapy, and then I think we are in a position to re-engage consideration for the positioning of the children.
Okay, I'll leave my questions there and hand it over to my friend.
Thank you.
Sir, I understand that you have prepared parenting assessments in a significant number of cases where the director has brought an application for various orders. Would you agree?
Yes.
And in those situations, would you agree that the majority of your assessments have been supportive of the director's application?
Either fully or partially.
All right. For the majority.
Fully or partially, yes.
And in the cases that you've done so, in all those cases would not have been the director who retained you and subsequently paid your fee?
In the cases, yes, so in those cases, the director is the one who's retained me. Yes, that's correct.
Now, you've indicated that the mother, my client, has shown a fair degree of cooperativeness.
Yes.
You've advised her that the result of your assessment could be contrary to her position, that it could be negative as far as she's concerned?
Yes. And just to be clear, it's done in two forms. One is verbally. I go through the consent process verbally, and then I have the client read and then ask me any questions before I ask the client to sign the consent. And so in both mechanisms, those boundaries to confidentiality are clearly laid out.
And you used the word understand on the part of the person you're assessing. Is it fair to say that my client did achieve a fair degree of understanding of what you're telling her?
Yes, part of that consent process is I will explore in my verbal part to ensure that they do understand.
So she did.
Yes,
And she was cooperative. You used that term to describe her.
I did.
And what ways was she cooperative?
She attended as scheduled. She completed the task. She allowed me access to information. And as I indicated in my examination in chief, I would say that they reached a point in the assessment where she decided to open up in an area that she had not previously discussed or disclosed to my knowledge. I would say there was a significant shift in her attitude towards the assessment at that point. Up to that point, I would say she was pro forma. In other words, she was doing what was asked of her, but sort of, if I'm asked to do A, I will do A, but not A+. Whereas following that disclosure, she engaged in the assessment process quite differently.
Fair to say she became more comfortable in the relationship between the two of you?
More trusting. I'm not sure it was comfortable.
Better term, thank you for that. So she trusted you, to your impression,
Yes,
and she was forthcoming, honest with you, gave you information you were unaware of,
correct.
information that was not necessarily positive about her history.
Correct.
So she was very open with you,
Yes.
worked with you well.
Yes. As I say, I think there's those two periods, the before and after the disclosure, and so that there was quite a shift after the disclosure.
For the positive.
Yes.
And you would consider this to be a good assessment.
Yes.
And it's a good assessment because of the attitude and cooperativeness on the part of my client.
Certainly, that was a major factor.
All right. Now, you've indicated that parents face certain challenging during the course of their parenting of their children.
Yes.
So it's not unusual for a parent to face challenges.
No, I would say probably most of us do.
Certainly. And you've indicated that a superior parent is a rare thing, if at all.
Yes.
So like a figment of your imagination, like Santa Claus.
No, there are some parents who are, they're truly the textbook parent, but most of us are a little more human.
Okay. And you've indicated it's very important for a client to understand, have that understanding if things are going to work, if things are going to improve.
Yes.
Now, I've heard the evidence of both the caseworker and I've heard your evidence in response to questions by my friends. It's my impression, and correct me if I'm wrong, but it seems you had a better, more trusting relationship with my client than the caseworker.
I think that's difficult for me to judge. The only frame I can put it to you is that for reasons that are unique to her, she decided to trust me with information not previously told. And you would have to ask your client directly why she would not have felt comfortable or felt differently with the caseworker. She certainly described she felt differently with the caseworker, but I can't go beyond that.
Fair enough, but she attended all the meetings that were scheduled.
That is correct.
She gave you information above and beyond what was in the collateral sources, such as the records of child welfare.
That too is correct.
Any idea why you can attest to why you seem to have such a good relationship with this client, but not necessarily with the caseworker? If you can't answer the question, that's fine, but do you have any insight?
I can only tell you about me. I can't do that comparison.
All right, that's
I
fair.
mean, there is one thing I would tell my students in response to that, Mr. Nicholson, is the role and authority of the person can influence how a client sees a relationship.
All right, but we've also talked about understanding. Do you think it might be that you had the ability to make her understand exactly what, for example, the purpose of the meetings with you were, what the concerns had to be addressed, that she really understand, formed the basis of her eventually learning to trust you and cooperate fully and even above what was expected of her?
I would love it if I could sort of say, yes, I was that brilliant, but I think it's a function of the work, but it's also a function of the time and space that a client might be in. It can also be a function of the client doing some internal assessing of the implications for where she's at in her life. There is a sort of a famous line that was originated by a psychiatrist in Vancouver in the early 70s, and he said that clients assess the cost of change versus the cost of the status quo and then make a decision. And so part of what goes on in the process of an assessment is there are opportunities for the client to say, what's the status quo going to cost me? What's change going to cost me? And which price am I willing to pay? And that's an insightful process.
And to have that insight, they have to have a good understanding of what they're contemplating.
Yes, so part of the assessment process is you are laying out the factors for the client.
Personalities could come into play, could they not?
Yes.
Fair enough. You've indicated that she's shown the ability to recognize the issues that she has to deal with.
Mm-hmm. Yes, sorry.
And she's shown moments of good parenting.
Yes.
Okay. She's demonstrating a willingness and a degree of insight.
Yes.
Those are all positive features, are they not?
Yes, they are.
And you're aware of the effect that it can have when you separate children from parents.
Yes.
And you're aware the legislation addresses that the family is the basic unit of society.
Correct.
And you're aware that when it comes to child protection involvement, the recognized procedure on the part of Children's Services is to take the least intrusive involvement possible.
That is correct.
And you've indicated she's shown moments of good parenting.
Yes.
So she has the ability to be a good enough parent, if not a superior parent.
She is showing elements and possibilities of being a good enough parenting. That is correct.
All right. And there's a question about exposing children to concerns.
Yes.
And she has taken some steps to prevent the children from being exposed. Maybe they weren't that successful, but she took steps like, with respect to her drug addiction, she would have a babysitter come over. Is that your understanding?
That's my understanding.
All right. And that may not have worked, but she still demonstrated the insight not to expose her children to concerns.
Well, the attempt to do that, yes.
It's the attempt.
Yes.
So there's a recognition on her part and an attempt to
Yes.
take a more appropriate action. May not be the best action, but she made that attempt, did she
No,
not?
and there's some downside to that when you look at that in its totality, and I think it's a really important area that you're exploring. So you have this quixotic pull. On the one hand, you have this her insight and her recognition that she shouldn't expose the children to that, and that at times she arranges appropriate care. And then you have times where she has struggles to engage with the children, and as she described, at times that causes her to withdraw, which is where Mary has stepped in. So you have these tugs in terms of what she does and how she responds. And if you think about what she's described for me in terms of the trauma, this reaction pattern would be quite consistent with that untreated trauma.
Right. So she has childhood trauma that she's told you about.
Yeah.
Is that a yes?
Yes.
And she's got some addiction problems.
Some substance abuse issues, yes.
You mentioned marijuana, but that's legal, is it not?
Yes, so the question for me is not one of legality or illegality. The question for me is purpose and context. So in your client's case, her substance use is an alternative mechanism to attempt to treat trauma, and it leads to sometimes reasonably adaptive behavior and sometimes quite maladaptive behavior. So for me, it's not, we could be talking aspirin, we could be talking alcohol, and we could be talking cocaine. And so to me, it's the purpose and the impact.
So would you agree with me, sir, that she's not, to use the term, a bad parent, but she's a parent that needs help?
She is a parent whose capacities are at times evident and at times blocked. So there's an inconsistency in that parenting capacity.
Would you agree that she needs help?
Yes.
Thank you. Now, play therapy.
Yes.
Children do not need to be in care for play therapy, do they?
No?
Now, the many occasions when you've come to court to give evidence with respect to applications by the director, is it fair to say that those applications have varied? It may on one hand be for a supervision order, maybe another time for a temporary guardianship order, and maybe the most intrusive application for a permanent guardianship order.
Yes?
And you've appeared and given evidence in all those situations, is that correct?
Yes, that's correct.
All right. Given your familiarity with the various type of applications the director in its discretion can bring, are there times when you've not necessarily supported the particular application the director has brought?
Yes.
All right. And there's even a process where children can come into the care director for a period of time without a court application. Are you aware of that?
Yes.
Custody agreement.
Custody agreements, yes.
Have you thought about the benefit of a custody agreement as opposed to a temporary guardianship application? Are there benefits?
Custody agreements are, I'm going to speak not as a lawyer, and but clearly I'm going to speak from a psychological or social work perspective. Custody agreements are where parents, I think, have a very clear recognition of what the problems are, that they are not in a position to engage in their parenting at that time. They have a good working relationship with the director, and there's a clear plan for intervention. There's a clear plan for the ways in which change are going to occur, and there's clear evidence that the change process is quite underway.
In response to my friend's questions, you stated that my client recognizes the issues. Do you remember saying that?
I do. My caveat on that is, as I just said, is the change process underway, and at this point it is not. At this point what we have is recognition, and so there is a need for a change process to get underway.
You also use the term willingness.
Yes?
So we see recognition, we see willingness,
Correct?
and this is the first time the director has applied for a court order. Is that not correct to your understanding?
That's my understanding.
And is your further understanding that the director has never requested on my client that she enter into a custody agreement?
I'm not aware that they have, but I can't say for certainty.
So you don't know?
I don't know.
Okay, fair enough. Now, even if my client were unwilling to enter into a custody agreement, there's still the prospect of a supervision order. You're aware of that?
Yes?
And in that case, the children could remain with their mother in the family unit, correct?
Yes?
And there could be specific provisions in that supervision order.
Yes?
Children attend play therapy, for one.
Yes?
The mother could be required to enter into an addictions program.
Yes, although I don't think she would agree with that.
You don't know, do you?
Well, when I asked her, she said no.
You didn't tell my friend that.
She didn't ask. It's in my report. It's in my report.
I see. Do you know if the director has requested that of her?
She says the director has.
I see. But what we're not talking about is an agreement for a custody order. We're talking about a court order, whether the mother agrees or not. There's a difference, isn't there?
There can be, yes.
Well, there is a difference between the two situations.
Well, yes.
All right, so it's not can be, it's a fact. There is a
There's a difference, yes.
Thank you. So, do you think you could modify your recommendation for, say, a supervision order? I mean, if it,
So
it's got a couple of benefits. For example, if it works, then it was the right order. If it doesn't, then it would attest more firmly that an application, a subsequent application by the director for a temporary guardianship order would be the appropriate order. So there's more than one benefit. Would you agree?
Well, you asked if I would modify my recommendation. And so I see, and then you gave some possible pathways to it. For me, in terms of the information available to me, when I contemplate, as I'm directed to do by the Act, the best interest of the child, then the best interest of the child is not to experiment with the child, to see about the mother's ability to engage and to be successful. One of the things that I think is very, very important, and I appreciate the position that you're taking because it is one that I have given a lot of consideration to. One of the things we see with individuals, to begin with, your client has disclosed for the first time a major trauma. We know from our research that the transition from disclosure to therapy is very difficult, and that the therapy can be very rocky, because what you're beginning to do is you're beginning to engage the client in a process of reconnecting with emotion that they have subsumed for a very long time in the case of your client. And At this point, she still says, when I last met with her, that the use of substances is a mechanism to cope with the triggers and the responses to the triggers. We know that Mary has engaged, as a result of the mother's coping mechanisms, has had to engage in a significant amount of parenting on her own and has taken over much more of that role than has Laura. We equally know that the first several sessions of therapy can be very disruptive, particularly with individuals with trauma. As I've mentioned, I think that she should also meet with a psychiatrist to determine if we might use some medication as a way to begin to calm some of those reaction patterns while we engage the assessment, or sorry, the therapeutic process. That's a volatile period for the majority of people. Now, can I say with certainty that's going to be true for your client? No. But I can tell you that the research literature is very clear, the clinical literature is very clear, that that transition from disclosure into therapy and into new coping mechanisms is a volatile process. There's also a really important issue in front of your client, and she's aware of this issue, is that she contemplates whether or not she should be involving the police. She doesn't know the answer to that question. And I'm not a lawyer, I'm not in a position to give her legal advice. But the fact that that's also part of the question is a really crucial piece. So for me, the issue that you're raising is a legitimate question, but when I contemplate the transition period and the move towards the therapeutic engagement, therapeutic progress, and then starting to get some stability, that's, as I said in my examination, then I think we should come back and revisit this question.
All right, I understand what you're saying. This is a complex issue. You've highlighted what I've put to you before, that my client needs some assistance. Now,
I don't want to minimize that. So I don't want to play word games, but for me, it's not some, it's significant.
all right. Now, what we're talking about is, one, willingness to participate on part of the client. Two, the presence or lack of insight on the part of the client. Those first two you've answered in a positive respect towards my client.
Yes, so let me put a boundary
sir,
there.
Please wait, let me finish. I haven't interrupted you, and I'd be very appreciative if you extend to me the same courtesy.
Certainly.
Moving on from those two, there are other issues. Attendance with a psychiatrist. That can be stipulated in an order, whether it be a temporary guardianship order or a supervision order. Taking other forms of treatment, that can be in either a supervision order or a temporary guardianship order. So the issue isn't what type of order would be more appropriate to ensure my client's cooperation. Okay. Those could be orders of the court in either order. It's not where one would be more influential on my client than the other. Would you agree?
I would have reservations about where you're leading me.
Well,
Because, with all due respect, Mr. Nicholson, I think that the piece, I agree with everything you've just said, but the piece that's not in that equation, that's very, very important from a clinical perspective, is the need for that stability to be present for the return of the children, so that a different environment where Mary is not taking on these parenting roles, where your client is developed new coping mechanisms so as not to be reactive in the way that she has been. If we simply think about how is it in the best interest of the children to go into a situation where mom is going into this emotionally difficult process? And I would also suggest, how is it in mom's best interest to be trying to repair her parenting while she's dealing with this brand new disclosure and the implications of it? So where I think that you and I are differing is the timing of examining return of the children to parental care.
Fair enough. And I understand what you're saying about the difficulties the mother may face. And there are also the difficulties about being separated from her children, and also the effect of that on the children. Is that not a factor of consideration?
It is, and so you'll notice in the recommendations we talk about the continuance of relationship between the mother and the children. That's going to require some work on Laura's behalf so that she doesn't absent herself, as she described to me, from those visits, and that she learn to be able to be fully present in those, in other words, to show up for those visits, but also to learn how to be the parent in those visits. So there's also learning to be done, teaching to be done in those visits.
And there could be teaching if the children remained in her care. Would you not agree?
For the reasons I've previously stated, I'm just not prepared to go into a position of supporting that for clinical reasons. I certainly understand your reason for putting it forward, but clinically it's not something that I'm in a position to support.
All right. But there could be teaching with respect to parenting skills if the children remain with the mother.
That's a theoretical possibility, yes.
It's a yes, right?
It's a theoretical possibility.
All right. And if there is a supervision order, that could provide for the provision of instruction in the area of parenting.
But that's not going to address the issues that I've just finished laying out for you. Yes, it could provide instruction, but it's a substantial shift from what I've been saying is clinically needed. And so I recognize that you're asking me to explore options. I need to be able to come back and say, from a clinical perspective, as an expert offering advice to the court, this is the formula that is making the most clinical sense in my experience. Yes, those other options theoretically exist, but clinically I'm not prepared to support those for the reasons I've outlined. So in answer to your question, yes, it's possible, but should it be done in this clinical situation? I don't think so. That's not my recommendation.
Would you agree with me that the primary consideration is the safety of the children and their well-being?
The best interests of the children, yes.
Whichever way you want to put it.
Yes.
And there could not only be assistance, therapy for the mother and the children if necessary, there could be parenting instruction to the mother if the children remain in the home under a supervision order, and there could be regular, specified, or unannounced visits by the child protection worker to check on the family on a regular basis. That could be in place, could it not?
It could be, but it is not my opinion that that is in the best interest of the children.
I'm aware of that. I have no further questions.
All right, so welcome back. You've watched a few court processes, and now Jonathan is back in his role that he was in at the beginning as the judge. So Jonathan, can you talk a bit about the role of the judge in the next steps here?
Well, it's a very difficult decision for a judge to make in that removing children from the care of parents is a very major step. And the judges often find that this is probably the most difficult decision they're called upon to make. The judge will have heard the evidence of both sides, and he'll have to make a decision as to which side has presented the evidence of either swaying the judge to grant the application or alternatively denying the application. One thing to be aware of in child protection proceedings is the judge does not necessarily have to make a decision either to grant the director's application or to dismiss the application of the director. The judge can make any other order possible under the legislation. For example, if the judge is convinced that a supervision order is in order rather than a temporary guardianship order, then the judge can make that decision. Or can decide that the director's application for a temporary guardianship order is the appropriate order, grant that application, And in some cases, the court has been so concerned about the evidence put forth by the director through the worker, the other witnesses, and submissions of counsel, could grant, for example, a permanent guardianship order. And these situations have occurred, which is why the judge at the start of the proceedings will warn and advise all parties that the court has that residual power. Sometimes when the court has done that, then the parent, for example, said, I don't want to take that risk. I think I'll agree to the temporary guardianship order rather than running the risk of the court saying, no, that's not good enough. I think there should be a permanent guardianship order.
So in the last section where you will have watched Dr. Choate give his evidence, myself ask him to present the information in the assessment, and then Jonathan played the role of defense counsel. You will have seen defense counsel really trying to get some certain pieces of information on the record. Did you want to just add a little bit more to that, Jonathan?
Well, yes, I'm trying to focus on some positive aspects on the part of my client, and you would have noted things like my client has demonstrated insight, my client has demonstrated a willingness to cooperate, my client recognizes the issues. There are times when my client demonstrates the ability to be a good parent, and combined with that, I'm also trying to focus on the seriousness of taking the children out of the care of their mother. So I'm trying to put forth the best case scenario on the part of my client and say to the court in my submissions, let's be very, very careful here before we take the children out of the care of the mother. This is not a lost cause on the part of the mother. She's showing some good aspects and some good potential. She needs the opportunity to show further abilities on her part.
And Dr. Choate, what was it like being an expert witness? What did you need to pay attention to?
So I think there's a line that you're constantly following where you are being, your role is to be neutral. Your role is to defend, and I don't even like that term really, but to present your opinion and to continue to explain why your opinion makes sense. But at the same time, it is important to listen to the questions the counsel puts forward, because they may put forward ideas that are worth consideration, that may cause you to change your opinion. There are times as well where counsel for the parent may present you with new information, and you have an obligation to consider new information. So for me, you're not in I'm not in a battle. For me, I'm in a position to inform the court, to try to listen carefully to the questions that are put, and to offer answers. But you'll also note there was a point where Jonathan attempted to sort of steer me further, and that's also one of the things that you've got to be able to say is, I get that as a theoretical possibility, but clinically I'm not going there. And so sometimes you have to sort of lay out some boundaries. I probably, Jonathan, talk more than might some others, just from the vantage point that I think I have some comfort with the court. But I also tried to show a series of, you asked a bunch of yes and no questions, and I just sort of played along with those because there's a time to push your opinion, and there's a time not to.
All right. Did you want to add anything to that, Jonathan?
I don't think so. I think that's pretty clear.
All right, so we thank you for watching. These will be part of a conversation that will happen in some of your classes around court, around families, around decision making, around assessment. This fits in so many of the different components of social work practice that you're going to learn about. So we will revisit this in many ways across your education here.